right. So many of you have been informed that anytime you're acting as a police officer, you can be sued for anything at any time. And that's simply not true. So what we're going to talk to you about today is when can you actually be sued as a police officer. So there's a lot of issue regarding something called qualified immunity. Do police officers in Texas have qualified immunity? Well, the answer to that question is yes and no. But more importantly, you have statutory immunity, which is actually stronger than qualified immunity. So whenever you're dealing with the issue of qualified immunity, what they're trying to say is, can you be sued personally for something you've done while acting as a police officer within the course and scope of your employment as a police officer with your agency, or a sheriff's deputy or deputy constable? What we're going to explore is something called the Civil Practices and Remedies Code, which is really what defines liability in Texas. And so most of the answers to these questions are going to be found within Chapter 101 of the Civil Practices and Remedies Code. Okay, so let's start. What is government liability? So when you look at Section 101.021 of the Texas Civil Practices and Remedies Code, otherwise known as the CPRC, a governmental unit in the state is liable for property damage, personal injury, and death proximately caused by the wrongful act or omission or the negligence of an employee acting within his scope of employment if the property damage, personal injury, or death arises from the operation or use of a motor-driven vehicle or motor-driven equipment, and the employee would be personally liable to the claimant according to Texas law. So you're driving your patrol car, you don't stop at a red light, or you fail to maintain a single lane of traffic, or you hit a curb and get diverted because you overcorrected your vehicle after hitting a curb while driving at a high rate of speed. Can you personally be sued? Well, we go down to 101.106 of the CPRC, and we start looking for our answers about what exactly a person who wants to sue a police officer, and by extension a fireman, an ambulance driver, or any really municipal employee acting in the course and scope of their employment. But for us today, we're talking about police officers. And in 101.106, what we find is something called election of remedies. What the CPRC is talking about here is what can a plaintiff, a person who wants to sue for? And how and who, most importantly, who can they sue? So let's say you're driving your patrol car, you have an accident, or you are firing your weapon and you hit an innocent bystander, or you're using your taser and you hit someone unintentionally who you did not intend to hit with your taser, something along those lines. And now the person who has been hurt wants to sue. In Texas, can you personally be held liable? In other words, can they come after your house? Can they come after your car? Can they come after your kid's college fund? Can they come after your retirement? And the answer is no, they cannot. Okay. So the first thing we have to look at is who can a plaintiff sue? And that's found here, election of remedies. The filing of a suit under this chapter against a governmental unit constitutes an irrevocable election by the plaintiff and immediately and forever bars any suit of recovery by the plaintiff against any individual employee. So when you're acting as a police officer, and more than likely you're going to have an accident. Every police officer does. If you drive long enough in patrol, you're going to have an accident. Even if it's not your fault, people will try to say it was. When the plaintiff tries to sue the municipality or the county or the Texas Department of Public Safety, whoever it is you work for, once they make the election to sue the government, the governmental entity that you work for, they are immediately and forever barred from suing you personally. Now, let's say they are silly enough, or the attorney handling the case is not paying attention and sues you personally when they should have sued the government. In the next paragraph, paragraph B, the filing of a suit against any employee of a governmental unit constitutes an irrevocable election by the plaintiff and immediately and forever bars any suit or recovery by the plaintiff against the governmental unit. So if you are sued personally, well, we're going to see how that is a huge mistake for the plaintiff to do. Because if, and we go down here to paragraph F, if a suit is filed against an employee of a governmental unit based on conduct within the general scope of that employee's employment, and that's a very broad term. General scope is a very, very broad term, and I can assure you that Texas courts interpret it broadly. So, for example, you're not in uniform, but you're not on duty. You're standing in a bank robber comes in. The Code of Criminal Procedure kicks in because you're a licensed Texas peace officer. You take action. You shoot the suspect. And the family of the suspect decides they want to sue you for wrongful death. Well, if they sue you, they're forever barred against going back and suing the government. So they're not going to do that. But more importantly, if you are acting in the general scope of your employment, and in that instant you would be, if a suit is filed against an employee of a governmental unit based on conduct within the general scope of that employee's employment, and if it could have been brought under this chapter against the governmental unit, and in that instance, it would have been. In a car accident involving your patrol car, it could be. And if it could have been brought under this chapter against the governmental unit, the suit is considered to be against the employee in the employee's official capacity only. And then on the employee's motion, in other words, your union attorney or your city attorney or county attorney representing you would, on a motion representing you, the suit against the employee shall be dismissed unless the plaintiff files amended pleadings dismissing the employee and naming the governmental unit as defendant on or before the 30th day after the date the motion is filed. So if you get sued and the government could have been, not should have been, just could have been, is enough, then the case against you, the employee, shall be dismissed. The court doesn't have the discretion to let it go forward. It shall be dismissed. Unless the plaintiff files amended pleadings dismissing the employee and naming the governmental unit. So they would have 30 days, the plaintiff would, to dismiss their case against you or to amend their pleadings, effectively dismissing the case against you and naming the governmental unit. Whichever department you work for, whichever city you work for, whichever county you work for, or if you work for the state of Texas. Now, if a trainer tells you, or some educator or journalist or some other activist tries to scare you into believing that you can be held personally liable in Texas, they simply don't know the law. Because the law in Texas is strictly enforced when it comes to governmental employees. The state of Texas, and really no appellate court in the state of Texas, allows employees acting in the course and scope of their employment to be held personally liable for those actions that they engage in, negligently or otherwise, in the state of Texas.